Greetings, my dear people of Biafra land. We all know that today is the day for our Onyendu MAZI NNAMDI KANU to receive his freedom. So I believe and I am sure that each and every one of the Biafrans out there, both home and abroad, is really praying for him for a fair judgment and imminent release of our leader. Unconditionally, that is what we are praying. So the court sitting will be today, 13th of October in the year 2022, and the Court of Appeal judgment in case between the leader of the indigenous people of Biafra and then NNAMDI KANU, the federal government, on Thursday. KANU's lawyer Ejimakor made this known on Wednesday in a statement titled "Update on Onyendu's Court Appeal Case." Earlier, God reported that the separatist group leader, special counsel Ejimakor, led a team of other lawyers at the appellate court this morning in the appeal suit filed on September 5 on the year 2022. A statement by Ejiofor party read, "We wish to inform all of us, the followers of MAZI NNAMDI KANU, that we just received notification from the Court of Appeal, Abuja Judicial Division, that the long-awaited judgment in Onyendu MAZI NNAMDI KANU's appeal number CA/ABJ/CR/625/22 between MAZI NNAMDI KANU versus Federal Republic of Nigeria will be delivered tomorrow, that is being today, the 13th of September 2022 at 2 p.m. We are very excited with this news as we look forward to a victorious outing today. The hour has just come. Please do not relent in your prayers as they are positively impacting. We will surely have every cause to rejoice, for victory is ours and it shall end in praise. My dear people of Biafra land, our Onyendu also want the court to also judge this matter. That is KANU seeks to be joined in appeal against prescription of IPOB. So in other words, so he is trying to bring all these cases together, prescribing IPOB as a terrorist zone or a terrorist organization. He wants that case to be addressed in court today as well. As the appeal against the prescription of the indigenous people of Biafra, IPOB comes up for hearing today, Wednesday, at the Court of Appeal, Abuja. Our leader, MAZI NNAMDI Onyendu KANU, has appealed to be joined in the suit as an interested party. KANU's special counsel, Mr. Ejimakor, in a chat with the Vanguard, said he would be leading a team of other lawyers to make a case for his client. Yes, we are making a headway. Ejimakor said he had, on September 5, 2022, on behalf of KANU, filed a process before the Court of Appeal, seeking to be joined in the murder appeal suit. Today, I will lead a team of lawyers to the Court of Appeal, Abuja, to make a case for MAZI NNAMDI KANU to be joined as a named party in the appeal against the prescription of IPOB as a terrorist organization. He also said, and I quote, "I will also be in tag team with Machuku Ume-san, who is leading in the murder case against the prescription." Ejimakor tweeted earlier, KANU had in his application as an interested party expressed the dissatisfaction with the January 18, 2017 judgment of the Federal High Court, Abuja, prescribed over by Justice A. Abdul Kafarati, which prescribed IPOB. Below is KANU's proposed notice and grounds of appeal as made available to Vanguard by his lawyer. Take notice that the interested party/applicant, being dissatisfied with the decision of the Federal High Court sitting at Abuja, contained in a ruling of the Honorable Justice A. Abdul Kafarati in suit number F FHC/Abuja/CS/871/year 2017. Delivered on the 18th day of January 2018, more particularly set out at paragraph 2, do hereby file this proposed notice and grounds of appeal to the Court of Appeal upon the grounds set out at paragraph 3, and will at hearing of the appeal seek the relief set out in paragraph 4 of this notice and proposed grounds of appeal. Ground 1. The learned trial judge erred in law with when he ruled that the Honorable Attorney General, in his application experts exhibited documents showing the existence of threats to national security by the respondent/applicant, and I accordingly made the order by the order of 20th September 2017 prescribing the respondent that applicant organization arm of the firm view that the right of the applicant to private and family life, freedom of expression, right to peaceful assembly, and freedom of movement have not been infringed upon. I also hold that the applicant's right to fair hearing has not been violated by the grant on the expert order. The particulars of the error: A. The ex parte order of a prescription of the applicant and its listenings as a terrorist group violated applicant's constitutional right to fair hearing when the second respondent consequently upon the said order declaring and prescribing the appellant as a terrorist group, arrested, detained, and is currently prosecuting the applicant on charges of terrorism as a member and leader of the appellant on 6-count charges solely predicted on the said order pending on appeal. B. Charging the applicant with the offences enumerated above, which offences are wholly predicted on the said ex parte order and upon which the applicant was on the notice, violated applicant's constitutional rights, including particularly his right to fair hearing. Section 36, subsection 1 of the Constitution of the Federal Republic of Nigeria, as amended hereafter, the Constitution provides as follows: in the determination of his civil rights and obligations, including any questions or determination by or against any government authority, a person shall be entitled to a fair hearing within a reasonable time by a court or other tribunal establishment by law and constituted in such manner as to secure its independence and impartiality. C. The trial court misdirected itself in law and thus occasioned a grave miscarriage of justice that has adversely affected the applicant when it heard that the judge in chambers may, on application made by the Attorney General, presuppose that the application is said to be made ex parte. The learned trial judge lifted the words in small close quotes from section 2(1) subsection C of the Terrorism Prevention in bracket, I quote, Amendment Act 2013, which has used judge in chambers not ex parte in enacting the procedure for obtaining an order of prescription and the declaration of an entity as a terrorist organization. On the clear divergence between judge in chambers and ex parte, the current and treaty law is as follows. 1. The plain meaning of ex parte is not one and the same with judgment in chambers, whereas ex parte carries elements of one party only being heard even in open court, not necessarily in chambers. A judge in chambers does not mean that only one party would be heard. This would consider position was enunciated in Digni v. INEC number 1, 2010-18 NWRL PT 20 where the Supreme Court held as follows. The Supreme Court and any other courts are enjoined by the Constitution and rules of natural justice to observe such rules that ensure a fair hearing on trial. So our Oyendu, the amiable MAZI NNAMDI KANU, is also letting the court to know that he's not giving up, that they must not prescribe IPOB as a terrorist organization. And that is what he's trying to explain here. That is what his lawyer also in quote, saying that the federal government of Nigeria and the Chief Justice of the Federation and the judge that is handling this case must look into it. That is why Ejimakor and the rest of the lawyers have gathered to tender their own case against the Federal Republic of Nigeria for doing this to the MAZI NNAMDI KANU. And this includes chamber sittings where parties are absent and unrepresented. This cannot be achieved unless and until all parties are heard or given the opportunity of being heard. Their submissions on the issue or matter under consideration are presented by the process and their accompanying attachments. In the instant case, no fair hearing was granted to the 21st and 22nd respondents when the appeal was dismissed by the Supreme Court in chambers, and that amounted to nullity. Consequently, all the proceedings and the judgment given were set aside by the Supreme Court. Otapo versus the summon. In 1987 2 in brackets part 58 587 referred to paragraph GH 9 as DE. So this is what our Onyendu is trying to let us to understand, that the court case that is said to take place today have to be in two sections. One is to let our Onyendu free. The second one is also for the court to denounce the prescription of IPOB as an terrorist organization, which is not so. I never see even it take the Buhari administration to say that they to name the bandits terrorists. It takes them over 7 good years before they can say, oh, this one are bandits, so they are terrorists, so they are terrorizing our people, before they say they are criminals. But as it starts now, they tag them bandits. But at the end of the day, they are still giving them amnesty and rolling them into our Nigerian army. And that is why a lot of dead bodies is everywhere. Could you imagine what happened in the Sambisa forest, whereby one of the soldiers that is fighting insurgency is now selling ammunition that they used to fight their enemies to the enemies? That means it's one of those ones that have been recruited into the army from, as they say, they call them repentant Boko Haram. My brother, there's nothing like repentant Boko Haram. Once a Boko Haram is always a Boko Haram, anytime, any day. Their main aim is to kill. That is their main aim, is to kill, destroy. Giving them amnesty and calling them repentant Boko Haram have never solved any problem. I can never solve any problem in Nigeria. So my great people, as we are waiting for the job, for the court sitting to stand today, we also have to not relent in our prayers that today's court sitting will mark the end of anything that is disturbing or anything that is drawing the struggle of the Biafra backwards. So my people, as we are waiting, let us also keep on praying. Remember, I just say let me drop this little notice here for my people as we are waiting for the final result of today's court sitting. And we know that it will surely end in praise. Do not forget to subscribe, like, share my content, and always invite your families and friends for the good news. For I know that before this day runs down, you all will have to hear the good news of the freedom of our amiable leader, Onyendu MAZI NNAMDI KANU. Until I come your way again, remain blessed. Bye for now.